Hello and welcome to this edition of A Page from History. I am Nilanjan Mukhopadhyay. The summer months 30 years ago saw a huge political and legal controversy erupt in India just months after the assassination of Indira Gandhi and her son Rajiv Gandhi becoming Prime Minister. The Supreme Court delivered what has come to be known as the Shah Bano judgment, which raised a political and legal storm. The verdict became the center of a raging debate and emerged as a national level issue. The judgment was seen as on the one hand, as a milestone in Muslim women's search for justice. It was also seen as an attempt by the courts to interfere in the personal matters of religious minorities. The issue severely impacted future politics and remains a point of debate. The Supreme Court judgment opened with the line, "This appeal does not involve any question of constitutional importance." How wrong was the apex court? To discuss this very significant slice of Indian political history, I am joined by a highly distinguished panel of experts. My first guest on this program is Syed Zafar Mahmood, a former civil servant, someone who had played a very crucial role as the officer of special duty in the Sachar committee, which was study the situation and the position of minorities in this country. I have J.K. Bajaj, a very noted political scientist, a very leading voice representing a certain very articulated political viewpoint, who is also the director of the Center for Policy Studies. Purushottam Agarwal, a former member of the UPSC, but not in this program as a former member of UPSC, but as a renowned political scientist, somebody who has actually worked on issues of secularism and communalism. Syed Zafar Mahmood, I would like to begin with you to try to first of all understand what the Shah Bano case was all about. Today's television viewers would possibly know very little except that out there was a controversy, except that beyond that little is known.
Actually, the Shah Bano judgment is one of the most misunderstood judgments.
Right.
There are many judgments which are usually not read in detail by the people, and this is also like that. But then, because there was a certain angularity, social angularity revolving around this, so therefore the effect of not having read the judgment by the masses, by the people in general who are commenting on that, was severe.
Right.
So the actual reality is that it was very simple. That CRPC Article 25,
right,
which was amended one,
right,
and that was not taking into account, that was not applicable to Muslim law.
Right.
Simply because Muslim law, personal law, remains uncodified.
Right.
That's the only reason.
Right.
Otherwise, if it becomes codified, then the problem is gone. But then it remains uncodified.
Right.
So while on the other hand, for Hindu personal law and Sikh personal law, etc., there are laws of parliament.
Yes, yes.
So that takes care. So because of this absence of codification of Muslim law, what happened was that section 125 of the CRPC was not applicable.
Right.
And because of that,
and the Supreme Court said, that it would be applicable.
Yes.
That is what possibly resulted in a major.
So no. Just a minute. Yeah. Let me put in here that this was not a matter of controversy. Yes. That is the issue. That Supreme Court having said that CRPC is applicable to Muslims also, there is no problem. Right. And no Muslim, I don't think, who have read the judgment would have
any problems with that.
But the problem was with the obiter dicta.
Right.
The obiter dicta on the asides. The Supreme Court began its judgment with saying, I'll quote, "Degradation of women is a weak point of Islam."
Right.
See, just as sweeping remark in the beginning itself.
I'd like to take up this point a bit later in this program, as to what was in the judgment which really caused the problem.
So we should know in the beginning that what was the issue.
Right. We'll discuss it a bit more in detail later on. J.K. Bajaj, to get an opening remarks from you to understand, Zafar Mahmood Saab said that one of the least understood judgment of a very controversial judgment. How do you look at it, when we talk in terms of, with the benefit of hindsight? How do you look at that entire issue?
Professor Mahmood is very right that the judgment has too many of obiter dictas there, which need not have been there at all. The issue was simple. And it is also a very tragic issue.
And a very human issue.
A very tragic issue that there was this lady who had born 5 children to this man, who had spent, she was married in 1932 or 40 years she had spent. And she had lived with another wife that man had brought in. And at the end of it all, at the age of 60, she is told to leave the house, leave her matrimonial house. And the trial court grants her some less than 100 rupees per month, and the High Court raises it to perhaps 179 rupees per month, 79 or some 79.25. And the matter goes to the Supreme Court. And the Supreme Court is the crux of what they are saying is that the personal law is where it is. We are not interfering with it, but the maintenance of somebody who is going to become vagrant is not a matter of personal law, it's a matter of criminal law. It is the duty of the state to ensure that nobody becomes a vagrant. And that is why Section 125 CRPC applies in this case also, as it would apply in any case of vagrancy. So actually it's not changing the personal law it's only saying that when there's a person who is likely to go into vagrancy, who is likely to lose all maintenance, then the magistrate can assign, tell the husband that appropriate, reasonable maintenance may be paid. There was really nothing in that which anybody could have taken objection to, except
the remarks, and that's what possibly led to. Purushottam Agarwal, let's go back 30 years back. April, Supreme Court comes out with a judgment which is spontaneously seen by the media at that time, I do remember, as something very dramatic, something very progressive judgment at that time. It led to a tremendous debate within few weeks. When you go back and actually try to recapitulate what were the parameters of the debate, how would you actually frame it?
See, before coming to your question, let me just make one remark. This is, I think, the legacy of British judicial system, that our honorable judges actually consciously indulge in this exercise of making lengthy and sometimes quite irrelevant remarks, which do not have any actual bearing on the matter at hand. Whether Islam is a degrading religion for Muslims, or Islam is a equalitarian religion, or Hinduism is that, or Christianity is that, I do not think that on an issue that whether criminal code in this particular context is applicable to Muslims or not, I do not think that these kind of references, these kind of observations which are there in the judgment of plenty were required. But the point I wish to make by underlining this is this, that it is not the only judgment in which judges do this. They do it in every judgment. I can remind you of this famous Hindutva judgment also, which is also full of such unnecessary generalizations. That is one. Now, secondly, in fact, apart from the legal aspect, this judgment I remember distinctly because I was young and I was active in many ways in the social and political issues. This judgment actually was seen by the democratic community, democratic people, as a landmark judgment because it opened a possibility of Muslim women seeking redressal, not merely
through the laws of the land, but
not only through the personal law, but through the laws of land, and hence this judgment was seen as opening a way of actually, extending the idea of democratic citizenship in the legal sense. And therefore, this judgment was welcomed by many people, and precisely for the same reason. taking up these kind of observations in the judgment. Precisely because of these things, the so-called Muslim leadership tried to capitalize for itself and tried to touch the hypersensitivity of Muslim masses on the issues of religious identity, which has some valid reasons, this hypersensitivity. And sometimes I feel that it, instead of being encouraged, it should be negotiated in the democratic fashion. The sensitivity on symbolic issues like personal law, like a legal Muslim university, and many such things. To put it quite categorically, this focus on these kind of emotional issues has resulted in a situation that in 2005 such a committee had to remark that Muslim masses are actually worse off than the Dalits, so far as economic opportunities and social status is concerned. So this I think is a
we should discuss such a committee later. Since we have said so much about the judges, I think it's fair to say that before this bench, on behalf of various Muslim organizations, extensive arguments were made around
the All India Muslim Personal Law Board had decided
that the court came to this on its own. The various Muslim organizations implemented themselves.
Still, Mr. Bajaj, I would just tell you, this is my personal feeling. If I were the judge, I would still avoid making generalized statements about the entire Islamic.
I think we should equally say that there was no occasion for the Muslim organizations to come and implement themselves before that.
I think on this particular note of disagreement between two of our
I agree with it.
You agree with it? Yes. On this point of agreement,
Muslim organizations had no business to get involved.
They're absolutely
not. So it became a kind of a cause and effect kind of a situation that the All India Muslim Personal Law Board implemented and became a key party in this particular case.
Which to that point there was no
which probably led to the Supreme Court making judgments which were much wider than what Zafar Mahmood said, was not necessary comment.
Not required.
We will take a little break at this point and then come back for the next segment of this discussion. Though the legal battle was apparently for a few hundred rupees more, much greater issues were at stake. Stay with us. This program will continue. Welcome back to a page from history. We are discussing the Shah Bano case 30 years after the Supreme Court delivered the verdict that sparked such a big debate. 3 decades ago, the process of churning had already begun at this time. Zafar Mahmood, in the last segment, Purushottam Agarwal had made a point that the judgment definitely opened the avenues for Muslim women to seek redressal within a marriage which did not work out, within the framework of the laws of the land, not only within the domain of the personal law. To what extent do you think that this was necessary at that point, and to what extent do you think
what was necessary at that time?
For the necessary for women to actually have the opportunity to seek redressal within the laws of the land?
Yeah, I think there is nobody has any two opinions on that. There is a constitution, and there are citizens of India, and there is an opportunity, and there is a grievance. So why not get it redressed by taking recourse to the courts? There is no problem in that at all. And so far as it would have limited itself to there, yes, 125 CRPC is applicable to the Muslims also. It's fine, perfectly fine. But then, as I said earlier,
you said that there is a problem with the
judgment. Not so, and my colleagues have agreed with that also. That yes, because there were asides, there were comments, and there were obiter dicta. Like there was one we said last nail in the coffin of the Islamic law in India. So things like that. If I mean, why to talk about that? See, remain on that. My friend Mr. Bajaj just now said that and that Muslim organizations implemented themselves. Till that had happened, there was no obiter dicta. So I don't think that the reverse is true. Is equally that because Muslims had implemented themselves, therefore it was a obiter dicta. I don't think that can be imputed to the Supreme Court, Honorable Supreme Court. But then, as Mr. Agrawal had already said, that there are umpteen cases of different kinds in which obiter dicta is there, and that is the legacy of the British Raj. So I agree with that. But then here it did the damage. And why it did the damage? That is also very important, because we were just now talking about such a committee. So such a committees only gave the put together the data which has been collected by government agencies over years. So accordingly, it said that Muslims are in literacy way behind others. So that is one reason by itself, but that Muslims were not ready, masses, 30 years ago or the more, to fully understand and differentiate between these two things. So maybe that also got them swayed.
Right. Yes, Mr. Bajaj, I saw that you were wanting to say, interject.
No, I think such a committee we should discuss in some detail later.
Yeah,
because this...
no, maybe on another occasion,
on
not,
another
not
occasion,
when we are talking,
but for example,
that calls for a completely separate debate.
Mr. Mahmood just said
Yes.
that the Muslim masses
we
are
yes.
low in literacy compared to others.
Yes.
According to the data collected by such a committee, in at least
No,
half
no,
of...
no,
can I request
just let me
you
finish this.
From NSSO.
In at least half of the major states of India, according to their data, Muslim literacy is higher than the average and higher than those. So it is not as simple.
Committee also says that.
I'm saying such a
but
committee.
at the national level,
okay,
the government of India says
but
that.
come to the issue.
Yes, ultimately, I do not want to discuss that. What I want to come back and get the focus on Purushottam Agarwal. Let's go back to something completely different. We're talking about the mid-80s. We're talking about the 1985, 1986, at the time when we have a government with such a huge majority, 400 plus, unprecedented, never before, never after.
Right.
In such a situation, let's try to seek your opinion as to what was the political reaction of the state, of the ruling party, of the Congress.
That was most unfortunate.
How did it react?
You see,
and it went in different directions.
See, even if legally speaking, you cannot establish a cause and effect relationship, but politically it reads now, and it read even then, like something like this, that we will revoke the judgment by an act of the parliament, and we will unlock the gates of Ram Janam Bhoomi. So on one hand, we will be
most commonly
that is the fact. Yes. We will be appeasing the so-called hardline Muslim opinion on the one hand.
That was the belief of the Congress party at that point. Yes.
Yeah, and that was a huge miscalculation, not only for the Congress party, but more importantly for the entire nation.
Right.
For the entire politics in this country. Politics was polarized after this misadventure of Congress party. Under the leadership of Mr. Rajiv Gandhi, the politics of the country was polarized as never before after 1947.
Right. True.
Because on one hand, you undo a judgment, its practical part you undo by passing a law.
Right.
On the other hand, in order to appease the so-called other group, you again open the gate of a disputed structure by the order of an executive magistrate.
So
there's a problem. No, I'm already saying that.
Let me come to
but
this
politically, they seem to be connected.
Law being passed. In fact, this is a classical case of how the Muslims of this country are being taken for a ride repeatedly. And it is because the Muslim aristocracy demands the extreme. They went and they demanded the extreme. Let me. They demanded that this judgment be reversed, and the parliament reversed it. This led to its own consequences, whatever it was. But the fact remains that Muslims did get nothing out of it, because within about 10 years, the Supreme Court and various high courts during that period reinterpreted the law to actually bring it in consonance with 125.
Right.
I mean, the law as it stands today is exactly in consonance with 125. So the Muslims as a people got nothing, except
I agree with that.
Except that they got the bad name, but they forced the state to do something which it should not have done.
Right.
They took the state to the extreme. That is the issue which has to be discussed.
Let me go back to the question that which I asked Purushottam Agarwal, seeking his opinion. What is your opinion, Mr. Bajaj, of how the ruling party of that time reacted?
But that's how the ruling parties of India, that's the problem with the Indian secularism.
Right.
That the minorities in India are demanding the extreme, and the ruling parties are giving them that in sheer name. They don't get anything in return. Even today, last year, the minorities of India have demanded that they should be outside the Right to Education Act. And they have been granted this. Repeatedly, we are coming to a situation.
No, I am trying to understand. I'm not trying to generalize. Can I just say, I'm not trying to generalize things. I'm trying to understand that we had this verdict, and the Congress party started speaking in different voices. Mr. Zafar Mahmood.
Yeah.
This is what I'm trying to. Others we can keep on talking endlessly on this particular issue, which is one of the most contentious issues in this country, but which we must face. But at the moment, I'm trying to limit the discussion to the reaction of the Rajiv Gandhi-led Congress party and his government after the verdict came out. While on one hand there was a huge pressure from what Purushottam Agarwal had earlier pointed out from the civil society, saying that it is a very positive judgment which needs to be welcomed. On the other side, there was a backlash and led to a new Muslim leadership. In a situation like that, how would you assess the reaction within the Congress party?
I feel that it was a case of misplaced priorities as far as helping out, knowing the problems of Muslims and helping them out is concerned. So at that time, it was understood by the entire nation as if this is the main problem of the Muslims of India. While Muslims of India don't give a tuppence to it, that it's a very small insignificant thing. Now you minus the obiter dicta, then there is no problem at all. It goes all the way, no issues. So the real problems, finding out what are the problems of the Muslims of India, that the Congress party with 400 plus members should have attempted to know that and address that. So instead of that, they took a shorter route, that they jumped upon an opportunity and then made capital out of it and made the changes in the law, etc., which of course had repercussions that we have been discussing.
Bano judgment in itself is a legal entity, but its legacy is hugely political and complex, and you just cannot dissociate the legacy from the judgment now. The point is that this was unprecedented, as I told you, for two reasons. One, the unprecedented polarization. Two, this was also a classic case of Congress party trying to appease both the minority and majority communities.
So on this point,
let me just finish. See, the point is that in this Ayodhya dispute, a legal case for title suit had been going on since ages 1948 or 49. In 1986, all of a sudden, a magistrate orders a situation which actually changes the status quo in a politically fraught atmosphere. And after that, I believe this Babri Masjid Action Committee is formed.
That is formed
so this
that.
classic,
3 days after the
classic rule of action and reaction starts working.
And a year later, in 1987 January, they called for the boycott of the Republic Day, which escalated the entire crisis and made the Babri Masjid.
1989 you have this Rath Yatra, then in 90 you have problem and so on and so forth. That is why I am saying that Shah Bano cannot be seen, the Shah Bano judgment cannot be seen just as a legal entity. It has a huge political legacy.
This is what Purushottam Agarwal is saying. I want to bounce your the idea with you. There are two things which I just want to draw your attention to. One is that Mr. Lal Krishna Advani in his memoirs has written extensively about this particular episode in the history of India. And he said that the Rajiv Gandhi government thought that it is doing something very positive, but it actually turned out to be very detrimental. That is something which he actually writes. Second is that in one of the interviews which I had the I was fortunate to have gotten a couple of interviews with the Prime Minister Narendra Modi, of course much before he became the Prime Minister. He had talked about the Shah Bano case as being one of the main issues which became the kernel of the politics of the BJP in the 1980s.
That's right.
Very specifically, kernel. It became the core on which the politics evolved further. Now, I'm not sitting on passing judgmental things, but the point is that there is a correlation with what was happening within the country. So, how do you see this correlation?
No, I always feel disturbed when major events of history, historical development, we try to paste these on individual politicians and always politicians, not outside it. It's I think wrong to blame poor Rajiv Gandhi for having unleashed all this up to the Babri Masjid. It didn't happen that way because there's a history of a certain kind of secularism that we have adopted, which militates against the majority repeatedly, and there become issues where the majority finds that, look, this seems to be too much.
But if you go back and look at the political narrative of the growth of the BJP and of the other affiliated organizations in the 1980s, the Rajiv Gandhi government's decision on the Shah Bano case was used as a major campaign point.
Became the issue. But the fact remains, the way the Indian polity has been done, the constitution itself grants the right to everybody else to run educational institutions as to their liking and takes away that right from the Hindus. Where in the world this will be happening? And several things of this kind,
True.
from the beginning of independence, have been
you are repeatedly saying let's not talk about such a committee, but you are yourself quoting and Right to Education
No, I'd like to
not admitted
no,
that.
No, I think
we should discuss such a committee. I'm saying we should discuss.
He should
No,
decide
Mr.
what should be
Bajaj
discussed.
and Zafar Mahmood Sahab, I think I
Yeah.
need to just step in
No,
at this
no,
point. Use my
so
anchor's
it is-
prerogative to say
it
that
is-
it's time for me to take a little break,
Okay.
and then I'll come back and resume this conversation, and we'll ensure that we stick to the Shah Bano judgment,
Yeah.
and only that, and we are not going to talk about
then we
the
should
Sacha
talk
committee.
thread
We'll
back
not
for
talk
the
about the Sacha committee report.
Sacha committee,
As
I'm
the
very
drama over the Shah Bano verdict unfolded, it became more and more complicated. Gender and minority issues clouded each other. If we look at the events of that time, the Muslim intelligentsia on the one hand and political leadership of the community were sharply divided over the verdict. Was it good for the Muslim women, or did it interfere with the rights of the minorities? This is a basic question. These two questions kept on coming up. Stay tuned in. This program will continue. Welcome back to a page from history. For the past 30 years, there have been two distinct views. The first, that Rajiv Gandhi succumbed to the Muslim orthodoxy, and the second, that his government provided safeguards to the minorities. Purushottam Agarwal, I said that these have been the two basic questions. Succumbed to the orthodoxy or provided some kind of a safeguard?
Frankly, I will not judge that government so lightly.
Right.
It actually tried to play the political
Right.
game. It tried to play
It tried to be
smart.
too smart.
It tried to play too smart. Now one can name under the advice of late Mr. Arun Nehru. This
Right.
is a matter of historical record. You are
Right.
a journalist. You have done research in these matters.
Right.
You know all this. See, the point
Played a
was.
very suspicious role.
So the point was.
Put it very mildly.
So the point was, that is how I reconstruct the whole thing, that okay, Muslims are pissed off with this judgment, and the so-called Muslim community, forgetting about the fact that women are also part of the community, Hindu
Right.
or Muslim.
Right.
So to put it bluntly, Muslim males are very pissed off with this, or Muslim leaders are very pissed off with this, so let us do something. Now, Hindus are going to get angry about it, because unfortunately in this country the question of uniform civil code has been always negotiated and articulated in the language of communities, not in the language of genders.
Right.
The Muslim personal law or Hindu personal law or any personal law, to my mind, must be seen from the point of view of women,
Right.
not from the point of view of
View of the
so-called
men
so
who
community,
control
so-called
and
community.
run the religion.
So-called community.
Right.
And therefore the debate has always been distorted in this country on the personal law,
Right.
Muslim or whatever. So since we are doing some kind of favor,
Right.
quote unquote favor to Muslims,
Right.
by revoking this judgment by an act of parliament,
Right.
similarly let us do something in
Something
Ayodhya.
to appease also.
Ayodhya.
Right.
Let us also not forget that this Ayodhya dispute had its own history. Till 1949 to 1984, the matter was just a routine legal matter. In 1984, West Hindu Parishad decides to take it up in a big way. Ram Janmabhoomi Mukti Abhiyan Samiti is formed in Delhi in 1984,
Right.
and the mobilization starts. In 1986 or 1987, I think 1986 itself, the locks are opened, and actually the floodgates of very disturbing political trends are opened.
The
And it
locks
becomes a politics of competitive
if
communalism.
I actually go back and look at that particular period, Mr. J.K. Bajaj, when we talk about the locks opening and what is it linked with the Shah Bano judgment, again I'll come back to Mr. Advani's memoirs. He says that in early 86, when Rajiv Gandhi government was facing one crisis after another, the crisis had started coming up. Mr. Gandhi came to visit Mr. Advani at his Pandara Park house on a personal matter, and very casually asked him, what do you think of this Shah Bano issue, this judgment? Do you think anything can be done about it? Then in his memoirs, Mr. Advani writes that for the first time he realized that the government had already made up its mind. Mind you, someone so insightful as Mr. Advani is saying that he realized that the government had already made up its mind to bring a law to nullify the Supreme Court verdict. Now, in a situation like that, where you see, that there is a certain process which is going on within the Congress party as far as bringing about a new law. There has been various changes happening. Arif Muhammad Khan has already resigned from the Congress party. So there is immense churning going on. What Purushottam Agarwal is saying, you may possibly disagree with the second part, trying to link it with Ayodhya. The point is that the Rajiv Gandhi government was trying to be very smart. and eventually it fell between two stools.
I think when people, political personalities start claiming too much as agency in situations, there's a history of all these things. We must recognize that Rajiv Gandhi did not act on his own. The amount of Muslim mobilization on Shah Bano case that had taken place was not small. I was reading yesterday that in Indore, which is such a small town, that time it was even smaller, there was a rally of 1 lakh Muslims. And Shah Bano's son is saying that if they had thrown 1 stone each on my house, that small house wouldn't have remained there. So there was a massive mobilization to which Rajiv Gandhi was
and this mobilization is what Purushottam Agarwal was saying was being organized by the men within the particular community.
Men.
I think this is an unfortunate fact of life that Muslim masses are being mobilized on the wrong side repeatedly by their elite. There was no reason for any mobilization.
Just to add to this, Mr. Bajaj is absolutely right that Rajiv Gandhi government did, in fact Rajiv Gandhi government or any government would not have acted if they did not see the possibility of making some political capital out of it, to put it to that way. Anyway, whether you take it as a acting under pressure or acting for some political consideration, the point is that unfortunately Congress, claiming to be a secular and democratic party, and left parties and all other such parties, my question is that why there was not the similar counter mobilization. He's right that there are 1 lakh Muslims taking out a demonstration or procession like Indore. Indore has also been a traditional gad, traditional fortress of trade union movement.
It was one of the
Homi Daji won Lok Sabha seat
one of the major industrial centers.
And it also has been, at that time, it was a very strong place for a strong bastion of Congress also.
So it was a failure of the secular
forces. The point
also
is, the so-called secular and democratic forces never took the issue to the masses. They never tried to mobilize, precisely because on the communal matters pertaining either to majority or to minority, they want to play it
the two issues on which I need to get the opinion of Mrs. Zafar Mahmood. One is what Purushottam Agarwal has said, that the entire issue was being looked from the perspective of men within the community. The second is that there was no adequate mobilization and attempt to raise political awareness by the secular and democratic forces of the country to ensure that the Congress government did not pursue the kind of politics of polarizing the country on that particular issue. What is your opinion?
See, I fully appreciate the sentiment of Mr. Agarwal in the first point, that it was males versus females. But really speaking, my first statement when we began this discussion was that the judgment itself, the crux of the judgment itself, was not a point of issue. It was not an apple of discord. It was not an apple of discord. What was the apple of discord was the obiter dicta. As far as the obiter, just a minute. As far as the obiter dicta is concerned, there was not much difference. In fact, no difference between males and females, because both male and female Muslims got hurt because of the obiter dicta. So yes, fine.
So ultimately the basic difference was over the special rights being given to the Muslims.
We must point out that poor lady was forced to renounce that 500 rupees that she was granted.
That's what I'm saying.
That is a real tragedy. That ultimately the biggest tragedy is that
that I fully agree with that, and I'm sure I was not too mature at that time, but then there were millions of Muslims who would have sympathized with the lady. Just a minute.
Please.
Yes. And about your second point, that where you asked
the mobilization, counter mobilization from the secular,
and that he very nicely brought it up, Mr. Agarwal. So when I was writing my IAS examination, the essay was on politics is the art of gaining power and the craft of retaining it. That's what I had attempted. Now, what happened at that time in 85 or before that also, if the Congress party was in power, it was trying to retain itself in power. But somebody else was trying to gain power. And we should go back to the Sangh Parivar of
1985, any other political party was other political party was remotely close to gaining power.
Let me speak. Just a minute, one last minute. See, 1925, this Sangh Parivar started its activities in an organized fashion. So there is what and rightly so. Why not? They should have the right that they were looking at how to gain power.
Right.
So this was 1985. Shah Bano judgment came in handy. So Rajiv Gandhi did commit a mistake. Fine.
Yes.
See this obita dicta business. I completely agree with Sayyid Sahab. My complaint to the enlightened Muslim intelligentsia and more with the secular and democratic political forces in this country. Why could not and why did not they take the issue to the masses, saying that this part of the judgment we do not agree with, but the operative part of judgment has tremendous implications and it must be retained. That is number one. Number two, he is right. Sangh Parivar or any political entity, if it is there to ultimately gain the political power and to reconstruct the society in its own way.
Spread of its ideology.
So they are entitled to this, and that's perfectly fine in a democratic polity. No issue with that. You see, the point is that people did not realize at that time the significance of this kind of politics. Now I can tell you, and I don't want to name the person concerned, but you would recognize. I spoke to a very leading leader of CPI at that time, a late intellectual giant of CPI, and I warned him about 1984 meeting of VHP, 2 years before Shah Bano judgment. I told him that, sir, this mobilization of VHP for the liberation of the Ram Janam Bhoomi and all that is fraught with tremendous possibilities, and you should respond, you should preempt something. As is the wont with great communist intellectuals, he gave me a detailed analysis of the class structure of India and the class character of Indian bourgeoisie, national bourgeoisie or whatever bourgeoisie, and assured me that you are being too hypersensitive to all this, nothing is going to happen, working class will prevail. We know what happened, who prevailed and what happened. So the point, I am just coming to that, sir. Mr. Bajaj is right in a way. It's not just a question of individuals going wrong or right, Mr. Advani or Mr. Vajpayee or Mr. Shahabuddin. It's the question of not recognizing and responding to the historical forces unfolding themselves. And on this, I repeat, Nilanjan, 1985 Shah Bano judgment actually presents an unprecedented case of one, communal polarization, two, of indifference, rather ignorance of the democratic and secular political forces in this country. Right. They could not anticipate, they could not understand the implications either of the judgment or of the
Ram Janam Bhoomi. At that time it was the only opposition, the secular and democratic opposition was the only opposition.
Let me make one
BJP was in a very bad
which is I think essential. I don't think RSS was formed in 1925.
RSS was formed in 1925 but not to gain power.
Not to gain power.
That you are absolutely right. It was formed basically to transform society, let me put it on.
Civilizational interest. And let us also
national interest or whatever, but yeah, it was not exactly.
That's what they felt. That's what they felt. Yeah. That's what they
political involvement in politics begins only with 1950-51 with the formation of the Bharatiya Janata Sangh. Till that time, the RSS is scrupulously away from party politics.
And I think this should also be clear that issue of the Hindus reclaiming Ram Janam Bhoomi didn't start with the Shah Bano judgment.
No, certainly not. It did not. The Ram Janam,
it is a very long history.
It's a long movement, but
much longer than 19.
But in an organized manner, it was started in 1984.
You see, sir, the point is, the issue was there. The point I was remains, Bharatiya Janasangh never took it up from 1951 to 1984. Hindu Mahasabha, sir, just a minute.
Indian history is much longer than Bharatiya Janasangh.
But I am talking of Bharatiya Janasangh in a certain context. I know Indian history is longer than Bharatiya Janasangh. I know that. So is the Hindu history, by the way. But the point is that Hindu Mahasabha was there, Bharatiya Janasangh was there, nobody took it up. I am not denying that this dispute has been going for quite some time. I am not saying that the dispute started in 1984 or even in 1949. What I am saying that something significant happened in 1984 when RSS decided, VHP decided to constitute a Ram Janma Bhoomi Bhukti Yagya Nirmana.
You know, Pushpa,
that is something very important.
Mr. Bajaj,
one short point. Prashad Agrawal is repeatedly saying that the secularists did not take up the challenge and didn't. Secularists will never be able to take up challenges because they do not recognize the various forces of history.
That is a very interesting viewpoint which you have made. We'll take another break at this point, then come back for the next segment on this program. The Rajiv Gandhi government at that time had a brute majority with more than 400 seats in Lok Sabha. Yet it took the government more than a year to be sure if it could pass a law to nullify the judgment. Do not go away. This program continues. Welcome back to a page from history. We are talking about the events that followed the Shah Bano judgment 30 years ago. Mr. J.K. Bajaj, before we went in for a break, we were actually talking about the Ayodhya issue and whether we are trying to see whether there was any linkages with the Shah Bano case. But let's leave that aside for a moment, because the moment we start discussing Ayodhya, it becomes a completely wider issue. Let me request all the panelists not to talk about the Ayodhya issue at this particular point of time. Definitely the point is that the verdict came in April 1985. May 1986 is the time when the Muslim Women's Protection Act gets passed. A long time, despite a brute majority in Parliament. Why does it take the Congress so long to nullify the Supreme Court verdict? Not sure of its politics.
Parliament processes are long. It's not too long for the parliamentary processes to do this. It doesn't happen overnight in the parliamentary processes.
No,
in one year is not too long.
If you go back and look,
the Supreme Court, to decide decide on the review of that act it was 1986 that the review was filed, and it gave the judgment in 2001.
Courts take much longer, but a speedy executive should be able to act swifter. Was it trying to
parliamentary processes are not supposed to be fast like this, because this is a matter of negotiation. The government must also be thinking whether to do it or not.
The Rajiv Gandhi brought the bill as late as after almost a year of the verdict. It took them a full year to decide whether they want to actually bring a bill or not.
Takes negotiation.
Only after they must have been weighing their possible political losses, and they must be weighing their possible political advantages and disadvantages to go this side or that side. And number two, that of course after the judgment first has to descend among the Muslims themselves, masses in general, the leaders so-called, etc., and then mobilization, whatever. I mean, you have to go back in history, and all that takes time. And after it becomes a national issue, then the government wakes up, and then government takes its own time to think it through politically, and then afterwards takes the course whatever it thought it to be. I think that's
the political processes which ought to take time. They cannot happen overnight. But I think the issue we should decide, I'm not forcing this debate, but I think till the secularism of India and the secularists of India do not come to an understanding as to what secularism can mean in a functioning society, we are going to have these problems again and again. It's not a merely issue of
the moment we start talking about that, then that
we'll never be able to solve it.
The definition of secularism is something which
what kind of secularism we want?
We have not been able to actually reach a consensus. I do not see that any likelihood, because it's an issue on which there is possibly
a settlement on these issues will be good for the minorities of India also.
I agree with Mr. Bajaj.
Yes.
That in India, the society as such, and it's not a question of Hindu or Muslim communities, it's not a question of leaders and intellectual, society as such has actually not been able to really exactly define secularism for Indian context in a very functional and kind of lasting way. Nonetheless, in spite of all this, till 1985, the society was functioning on certain principles of accommodation, of negotiations and all that. And secularism or not secularism, any democratic society, any society with diversities cannot ignore the process of accommodations and negotiations. Unfortunately, what has happened now, that in the name of secularism, some kind of competitive appeasement of this or that, and I repeat, it's not the minority appeasement only. The important fact, whether it is connected or not, but the important fact that within a year you two political steps, one is related with Shah Bano, other is related with that disputed site, indicates a certain kind of politics which becomes detrimental. The second point, Nilanjan, I wish to make is this, that okay, let us debate about secularism, let us evolve a suitable concept of secularism. But in this entire case, there was a political manipulation of a legal process.
Right.
In both the ways.
It was done by the government of that time.
That, you see, I always believe that we can discuss about civil laws, we can discuss about the desirability of this civil law, or that civil law, or uniform civil code, or various religious civil codes. Are we really bothered about application of at least criminal law universally?
Right.
Are we really bothered about politicians at least showing the restraint not to play around with matters of legal and constitutional importance for political considerations?
Right.
That can be done even when we are indulging or we are undertaking the debate on secularism. So I am just saying that you just cannot say that unless the issue of secularism is finally settled.
No, I don't think Mr. Bajaj.
I am not saying that.
I don't think.
No,
I'm not saying
all
that.
I'm saying is
I'm not saying
that
that he means it. But the point is,
issues like Shah Bano
the point is,
are going to arise in Indian context repeatedly, because we have distorted the meaning of secularism to imply that the minorities in India will have a veto on the public expression of the mainstream's civilizational expressions. This is one of the rare countries, in fact perhaps the only country, where the constitution specifically grants the right to the minorities to carry out education the way they want, and specifically takes it away from the majority. And the whole constitution, the majority doesn't have the right to run its temples. Well, the minorities are given
the moment we talk about that,
this kind of secularism,
no, we are getting
doesn't
into
work.
No,
It's
I think
unsustainable.
no.
And so the Shah Bano kind of issues will keep arising, keep exploding.
I think again,
but sorry,
with that.
just a minute, sir.
Yeah.
I think again it is the typical case of overgeneralization, which we were complaining about in the context of that judgment. Britain has been having faith schools for years. Many countries in the world allow the expression of religious and community sentiments, and when, for example, something happens in USA which affects the sentiments of my community, I feel very disturbed here. But if something happens here which affects the sentiment of the minority community, I take it as a majority expression or expression of mainstream civilization. So, sir, please, I did not disturb you. The point I am trying to make is this, Nilanjan. I am not denying that secularism needs to be really defined in a very fine way, in a very suitable way, and in a context-specific way. Granted, completely agree. But the adherence to rule of law, the fidelity to the political and legal processes, and staying away from the temptation of appeasing minority or appeasing majority community, I think that can be practiced straight away. Whether you have proper concept of secularism or not. To my mind, the issues are actually not just of the secularism. In a deep philosophical sense, these are the issues of governance. And 1985 is the watershed, because there one particular government actually did something which affected the philosophy of governance for quite some time.
On this particular issue, I think there is absolutely no Zafar Mahmood on that. In 1985, after the Shah Bano verdict came up, and after the manner in which the Congress party reacted, succumbing to the pressures and taking away the right, ensuring that the criminal law would not be universally applicable to all members of society. Would you say that that in any way reflected a political myopia of the government of that time?
Definitely, that's what we have been discussing. That's what we have been discussing, that the government of the time it took the true import of the Supreme Court judgment from X to Y, and it took it into the political spectrum rather than remaining in the judicial spectrum, rather than remaining in the criminal spectrum, etc. So, as far as judicial criminal spectrum is concerned, there, as I have said earlier also, there was no problem at all. But then the government of the day decided to make capital out of that. And equally,
could they? Did they actually gain any benefit?
They tried this. They tried that. But then I think they did not succeed in that. But then it did become a flashpoint for competitive politics from both sides. Definitely, it did become. And the other side jumped upon this great godsend opportunity. So to that extent, yes.
Let me move to Mr. J.K. Bajaj, for your final comments on this particular program. It's time for me to move towards the summation of this program.
Let me just
Shah Bano case, the verdict and the way in which the government of that time reacted. 30 years later, that entire debate, what do you think is the stamp that it left on Indian
when we
politics?
look at an event of 30 years ago, we should look at it with much larger, longer historical perspective than what was happening at that particular time. And my feeling is that it is, for all of us, it has become very easy to blame the politicians of one time or other for the historical processes as they are unfolding.
But the government of that time cannot in any way be
it is easy to say that, but it doesn't help in any manner.
Right.
Because politicians are reacting to certain events in the society.
Right.
They are not just foolish people.
Right. Anyway, let's get to the point. I'm running out of time.
And this other question of that there should have bothered only about the criminal and legal aspects.
Right.
The criminal law already in 125 is what was being talked about. In 127 already it takes note of the personal law of the Muslims and makes special provisions.
Well,
so it is not that the law is above this.
I have to cut you short, because you have actually reached virtually the complete end of the time. It's been an issue on which the three of you have disagreed and have also agreed on a large number of issues. In fact, if we actually go back and look at this entire debate once again, we'll possibly find that there have been greater amount of agreement than disagreement. Of course, this entire process of agreement and disagreement has been tremendously animated. Thank you very much. I'm sorry, gentlemen, I've completely run out of time. Very few judgments have had such deep impact to the verdict in the Shah Bano case. The issues that were raised were relevant not just to courtrooms, but also in the political and social arena. You have heard different viewpoints, whether Rajiv Gandhi, the Prime Minister, faced a dilemma at all or not. If his final decision to opt for a new law to nullify the Supreme Court verdict was necessary or not. How should we weigh the individual women's rights against the rights of a minority group? We have also discussed how this entire episode impacted future politics of India. But like always, we shall not answer any of these questions, but leave it to you to form your own opinion. Do give us your feedback on this program and write to us. Our email ID is historylstv@gmail.com. We will return next week. There will be another page from history.